After a loved one has passed away, you may be wondering if you need to open a California probate in order to handle that person's affairs and transfer their assets to their heirs. Hello there, I'm Paul Groh, Director of the Estates Administration Department at the Law Offices of Daniel A. Hunt. In determining the appropriate procedure to use in administering an estate post-death depends on several factors: the size of the estate, the nature of the assets in the estate, how the assets were titled, including beneficiary designations, and whether the decedent, that is the legal term used to refer to the person who has passed away, whether they created any estate planning documents before they died. The probate court is the authority to supervise the processes that transfer legal title of property from the estate of the person who has died to his or her heirs or beneficiaries. But a fully court-supervised probate proceeding is not always necessary in every death. Opening a full probate matter with the court may not be necessary in the following 5 scenarios. First, the estate value is under the required threshold. If the estate or asset qualifies as a small estate, you may not need to open a full probate matter. If the total estate value of all assets is less than $166,250, that includes real property, or if the sole asset is a piece of real estate valued under $55,425, you can seek to avoid a full probate with a small estate affidavit. Consult an experienced probate lawyer for determining the best strategy. Second, your spouse has died and your assets were all community property. Since California is a community property state, this means that the widow's spouse has a right of survivorship. Community property with right of survivorship means that when the first spouse or partner dies, the couple's property automatically belongs to the survivor. The surviving spouse will not need to open a full probate. Third, the decedent owned all assets in joint tenancy with someone else. If all of the estate assets are titled in joint tenancy with another person, such as a partner or child, the joint tenant will inherit those properties at the decedent's passing. However, if the surviving tenant does not add a beneficiary or another joint tenant to the asset, a probate may be triggered when they pass away. Fourth, the decedent created a revocable living trust and transferred all estate assets of value into the trust. A revocable living trust avoids a California probate and will be administered privately by the successor trustee. Fifth, the decedent's only assets are retirement accounts or life insurance retirement accounts, and life insurance policies are paid out upon the owner's death to the designated beneficiary. They do not pass through the probate court system unless no beneficiary is designated on record for the asset. While some families may be able to avoid probate due to estate size or estate planning, a probate will need to occur under the following 3 circumstances. First, the decedent died with no estate plan at all in place. When a person dies without ever creating a last will and testament, this is called dying intestate. Assuming none of the previously described exceptions apply, someone, usually a family member, will need to petition the probate court to be appointed as the estate's personal representative or administrator. This individual will handle the estate administration and ultimately distribute the assets upon court order to the decedent's heirs. Second, the decedent died with only a will. While a revocable living trust avoids probate, a last will and testament does not. The executor named in the will must lodge an original copy of the decedent's will with the probate court and initiate the probate process by filing a petition to administer the estate. Once the probate is complete and the judge grants permission, the executor will distribute estate assets as outlined in the will. The whole process often takes 10 to 18 months or more in California. Third, the decedent created a revocable living trust but neglected to properly transfer assets into it. Even with the best of intentions, sometimes assets are inadvertently left outside of a trust. Maybe the settler never got around to changing the title on the large bank account. Maybe they refinanced their home and the house never got put back into the trust after the loan company took it out to complete the refinance. If an asset is left outside of the trust that exceeds the cutoff amount, the successor trustee may need to open a probate to administer the estate. Notwithstanding all that we have just talked about, there may be additional reasons you may choose to seek a full probate proceeding, as it can limit creditor claims, give court approval to estate actions, and provide an open venue for dealing with estate administration. You'll want an experienced probate attorney on your side to guide you through each step and offer you sound advice based on years of experience navigating the probate system. If you have any questions about how or when to open a probate, please contact our office. We hope this video has been helpful, and if you have any questions about estate administration, feel free to contact the law offices of Daniel Hunt using the information listed below. Thanks.